Hello, and welcome to SLW Institute's International IP Webinar Series. My name is Greg Stark, and I'm a principal with Schwegman Lundberg Woessner. Today's webinar is entitled Brexit, the UK is leaving the EU, but not Europe. What you need to know to maintain European-wide IP protection. We will be recording today's presentation, and it will be available on SLW Institute's website for future reference. To submit a question, please feel free to use the Q&A feature on the webinar menu. Also, please follow SLW Institute on LinkedIn for notification of future webinars and other useful information. My colleague, Dr. John Collins, has been kind enough to put together this webinar and will be presenting today. Dr. Collins is a UK and European patent and trademark attorney who heads the UK office of Schwegman Lundberg Woessner. John has considerable experience in proceedings before the European Patent Office, including oppositions and appeals. He is also well-versed in all forms of IP protection within the European community and a perfect speaker to sort out how things are about to change or not change on January 1st, 2021. Thank you for joining us. And with that, I will hand things over to John.
Thank you, Greg, and welcome everybody. Thank you for joining this presentation. What I'd like to talk about today, I'm sure a lot of you, really anybody who hasn't heard about too much about Brexit would have been living on a different planet. Brexit is a hot topic, and this is quite late in the day, 1st of December. We're only a month away from the impact of Brexit on IP rights. There is quite a broad spectrum of impact of Brexit on IP rights. I'm going to constrain myself to the four principal subjects: patents, copyright, designs, both registered and unregistered, and focusing on the EU design system. And similarly for trademarks, EU registered designs, and of course, pending applications. So without further ado, let's talk about patents. And the reason I've included this here really is to emphasize to US practitioners that nothing changes. The European patent system will continue. European patents can still be obtained covering the UK. This is because the European Patent Convention is not based on EU law. It is an international convention which is entered into individually by member states. For those of you who may have heard of the unitary patent or the EU patent system, this has been going for quite some time, but has stalled. And if it ever happens, which is questionable now, based on the EU's exit from the EU, for the UK's exit from the EU, because it was one of the principal proponents of the system. If it were to ever come into being, it would be administered as a designation of the European patent system in parallel with national rights. So just to remind everybody, the European Patent Convention, contracting states, there's a little map to show everybody, this includes a large number of countries. When you compare this to the EU countries here shown in blue, you can see that now this is the map shown as of 1st of January 2021, the UK shown in red outside the blue shading of the EU, and the UK will join such countries as Switzerland, Norway, Iceland, Turkey, to name some of them. So this is not unprecedented for a country who is a contracting state of the European Patent Convention to be outside the EU, and so we will operate on that basis, with no real change in, well, no change in the patent system. That's important message, no change for patents. Moving on to copyright. Copyright is a national right that EU country provides separately. So there are a number of EU directives, and a significant amount of EU law has entered UK law and impacted on UK copyright law for the purposes of uniformity of protection across member states. And the UK government has taken necessary steps to sort of erase reference to EU law within the copyright statute. But this really makes no change. It simply references or removes reference to EU law, but the impact on copyright will be, again, really no change. There's an international reciprocal protection system involved with copyright, and this will continue unchanged. What will change is some cross-border mechanisms. Of course, as the UK is a member of the EU, we have an open board and free movement of trade within the EU. As soon as we leave, the border goes up, and reciprocal cross-border arrangements will need to be amended, and regulations need to come into force on the 21st of January. However, and they are being negotiated, however, as yet, we don't have full clarity on what these will be. These negotiations are still underway, and Brexit still has an uncertain edge with only 1 month to go as to what will be the conditions regarding trade and indeed a number of these regulations. But in essence, that's one particular niche regarding the local effect within UK and across Europe, rather than the effect to US practitioners themselves. So let's take a look at registered designs now. As obviously, as US practitioners know these as design patents. In Europe, we call these registered designs. There is an EU design system, which is a unitary right. And the term we use is a registered community design, an RCD. So what is happening when the UK leaves this, we will not lose, I say we applicants and proprietors will not lose design protection in the UK. Instead, registered community designs will be copied, or what's the term that is cloned, it's been coined. Registered community designs will be cloned to the UK register. The filing date and the registration date of the cloned UK registered design will inherit that of its European counterpart, and the UK Intellectual Property Office will not charge for this. So you'll get a new UK registration, but you won't get a registration certificate. You can simply download a copy of the register to show that it's happened if you need proof. That's all there will be. Interestingly, this has happened in the last few weeks. Pressure from the UK profession partly, and the current legislation in the EU, you can have a representative or what we call an address for service, which is based on any address within the EU. This was at one point going to be left, but following pressure, I think, from a lot of representatives in the UK, this has now been rescinded, and a UK address for service will need to be provided for the new rights, and based on new law being implemented. Some of the details are still, well, the law has not been enacted yet. It will come into place on 1st of January, but that is something to be aware of. The cloned UK registered designs will be numbered with a new number to distinguish them from normal UK registrations. They're simply going to put a 9 in front. An example there shows the numbering system with the dash removed for multiple designs. In this case, that number showing 0004 would mean it's the 4th design in an application of at least 4 designs, maybe more. In the UK, each individual design is numbered with an individual number and not that sort of prefix, suffix. So the 004, this number is concatenated together with a 9 in front of it to give it a single number. So the UK design, registered design, will then be fully independent. A fully independent UK registered design that can be challenged, assigned, licensed, or renewed completely independently from the original registered community design. With regard to the Hague Agreement, registered designs have been registered in the EU through the Hague Agreement system, international registrations. These will be treated in the same manner and cloned across to the UK register. The only difference being that they will be identified now with a prefix number 8. The example given there shows a prefix with the D removed and 8 added before that. Pending EU registered designs. For pending designs, the system is not so straightforward. Pending registered community designs will not automatically extend to the UK. Generally, there should be very few of these. Most EU designs are registered very quickly, and you would be wise. I mean, I think the window now is very short, 4 weeks. I think there may be a few people trying to rush through, a few applicants rushing through some applications before. You can get them registered very quickly within weeks. I suspect there might be a backlog, a rush to try and get some registered before the 1st of January. So the door may be closing on that opportunity. But if you do file a European community design in a couple of weeks' time, it's likely that it will be pending and not automatically cloned across to the UK register. A UK application can be filed to benefit from the EU priority date. This new UK application must be for the same design. You can't start making changes, and so it's got to be identical. And the new UK design will benefit from the date of the EU application, but it will be examined under UK law. And the deadline for filing such new UK design applications is the 30th of September, 2021. So you've got 9 months. Now, if you file a design at the end of December, for example, 20th of December, pick a date, and it's not registered by the 1st of January, it may then get registered quite quickly in the first few weeks of January. It's suddenly an EU registered design, but you still then have several months until nearly 8 months plus until 30th of September to file an equivalent new UK design based on that EU application. For international applications, again, the Hague Agreement. This is it is identical, same system. They're not going to be copied across. If you have an international design application which designates the EU and it's not yet registered, you can file a new UK application benefiting from the international priority date, as long as the design is identical. And the new UK design will be examined under UK law, and the deadline for filing the UK application is 30th of September 2021. So exactly the same. Some general comments on EU registered designs, bearing in mind the Brexit considerations. It's possible, if you wish, for a registered design, an EU registered design owner to not want to. There may be some agreement, some reason that you should not hold a separate national UK design registration, and it is possible for the owner to opt out of ownership of a UK registered design, and that can be communicated to the UK IPO with appropriate details of the persons interested in the reason, not say a reason, but they're showing that they are the registered owner. With regard to the cloning procedure, of course, this will mean that the registered proprietor may have duplicate. This is often the case, that there is a UK registration and an EU registration, and indeed you now end up with a situation with a UK registration, a national registration, and an EU cloned, cloned registration of the EU registration. So it doesn't really change the circumstance. It just means, strangely, you end up with 2 UK national rights. With regard to a license or security of interest that refers to an RCD, if this authorises acts in the UK, this will be treated as if it applies to the cloned UK registered design. and the assigner or the assignee will have the right after Brexit to apply for the registration of the cloned UK design registration, because of course if the assignment is predated, that included UK, and the UK IPO will honour that, accept that assigned right and register it accordingly. One area gets a little bit confusing, registered design renewals, and this we'll talk a little bit more about trademarks as well. Renewals for designs due every 5 years, and whether it's a registered community design or an international registration, the renewal fee that falls due after the 1st of January, you can't pay this early, so that you can try to avoid paying a UK renewal fee. If it's due on the 1st of January or after, you will have to pay the UK renewal fee separately in order to maintain the UK cloned registration. So the renewal deadline for the cloned UK registrations will be calculated from the EU international registration dates. Of course, they inherit the priority dates. If we're in the complex, slightly more complicated situation where the registration falls due within 6 months from the 1st of January, if the fee hasn't been paid in time, the UK IPO take it upon themselves to notify the proprietor and set a further 6-month period normally. But of course, there will be a rush and a backlog. So the special provision has been given allowing a 6-month grace period from notification by the UK IPO, for which there will be no surcharge. So the UK IPO will sort of allow a bit more time without making the additional renewal fee charge obviously because of the rush here. With regard to renewal fee not being paid, restoration, if the design is cloned, then this is still a UK right, and UK restoration law still applies if you need to apply to restore an application, registration. With regard to late renewals, if you pay if a renewal fee is due and you haven't paid it, so you normally get your 6-month late period to pay the renewal, either as an international or as an RCD, the UK design registration will be cloned and will be set in an expired status. If you pay the renewal fee with EU IPO or international renewal fee, then the UK IPO can be sort of reinstated back in the renewed status. But there is a warning or a note, which is part of the information given by the UK IPO, that they need to be told this manually if it is an international application, and they need to be told by the 30th of September 2021 if you renew an international design registration. That note is not given with regard to EU registered community designs. I assume that they have a feed directly onto the register for such information, but they don't appear to have it from WIPO. So just prepare on that one. Time to then look at trademarks. And with trademarks, a lot of what I've said for registered designs applies equally. Trying to get meeting controls, bear with me. A lot of information applies equally. The registered EU trademarks will be cloned across to the UK register, and the filing date and registration date of the UK trademark will correspond to the date of the UK registration. So the same principle here, no right will be lost based on an EU registered trademark, and you will have the same registration and registration and filing date. No charge again, and no certificate. Same problem, or same consideration with regard to an address to service. The cloned UK registration will be numbered with the prefix UK009, with the first 3 zeros dropped off to distinguish these new cloned registrations from national applications. An example is given there of the numbering system. And the cloned UK registration will provide a fully independent trademark that can be challenged, licensed, assigned, renewed completely separately from the original EU trademark. For international designations of a Madrid Protocol application or registration, here, the EU designations of the international registrations will be cloned in the same way, and they will be assigned the priority date of the international registration. No charge again, an address for service in the UK must be provided. And looking at the numbering system here, they will be assigned with a prefix UK008 on the register. The important thing to consider here is that the cloned UK right will be treated as if it were applied for and registered under UK law. So yes, it can be assigned, challenged, licensed, etc., separately from the international registration. Now, this is quite important because normally your international registration stands or falls on the basis of your home registration. In this case, it completely divorces itself from the usual restrictions of an international application or an international registration. It becomes completely separate. So that is actually a significant difference. Looking at pending trademarks, pending EU trademark applications, again, same as for designs, will not automatically extend to the UK. A new UK trademark application can be filed, benefiting from the priority date. It must be for the same mark and for the same goods and or services that are identical or contained within. You can, of course, as ever, limit the goods and services or limit the number of classes within a trademark application. So your cloned new UK application, your newly filed UK trademark application could, of course, be narrower than the EU application. It will be examined under UK law, and the deadline, as for finding new design applications, the deadline for finding new trademark applications is the same, 30th September 2021. So looking at Madrid Protocol pending applications, this will look rather familiar to you because it's exactly the same. Pending designations, which are not subject to a statement of protection issued by the EU IPO. And that's really the statement of protection is the issue. Whether it's registered by WIPO is immaterial. It requires a statement of protection to be issued by the EPO accepting the registration. And if that's not in place, then it is deemed still pending in the EU IPO. And therefore, a new application can be filed based on the priority date, but it must be, again, for the same goods and services. And it will be examined with UK law, and the deadline, again, is the 30th of September, 9 months. If an EU international trademark has been subject to a notice of refusal issued by the EU IPO prior to the 1st of January, it cannot be used for the purpose of claiming an earlier date. So you've got this statement of protection, which closes the sort of registration process, and you've also got the notice of refusal, which puts it in an abandoned state and not possible for claiming as a new UK application. That's details of the international trademark system procedure. Some general points on registered trademarks. There's some similarities here with the EU registered designs. If the owner doesn't wish to hold a cloned UK trademark, you can opt out. Again, if you provide sufficient details to the UK IPO, you can opt out of owning that right, and it will be abandoned on the register. The result of the cloning procedure will be a number of duplicate rights, as I mentioned above for designs, but so that gives you sort of dual rights, and there may be significant overlap. Now, with regard to EU trademark law, of course, use of a trademark is important for defending against a potential non-use cancellation action. The important thing here is that any use of the mark in the EU, whether inside or outside the UK, made prior to Brexit Day, will count as use of the UK right for supporting or defence against non-use cancellation action. Similarly, this also applies to reputation. Again, getting into the nuances of trademarks, any seniority claim, which is based on an early UK or international UK trademark registration, so where an EU trademark was filed originally, claiming and trying to integrate, claiming seniority, integrating a UK national application to avoid paying national fees, renewal fees. That date is the seniority date and is retained within the EU right. That is retained and carried across to the UK trademark registration automatically and will apply to any new applications in the same way, so that seniority is not lost. Again, similarly, regarding general issues on EU registered trademarks, any license or security interest that refers to a trademark registration and authorises acts that were to be treated, it should be treated as if it applies to the UK cloned trademark registration. The assignments, under the assignment, the assignor, the assignee will have the right to apply for registration of the UK trademark. With regard to conversion, this is the ability within the EU trademark system generally when you hit a roadblock, when you get a refusal, to convert the EU trademark into national trademark applications. This will still be available, but for those trademarks that have been cancelled or surrendered or expired, they can be converted to a new UK trademark application, but a request for conversion must be made before Brexit, before the 31st of December. Okay, on the 31st December, before the 1st of January. After that, it's no longer possible to convert an EU trademark in a cancelled, surrendered, refused, expired state to a UK application. Moving on to renewals. EU trademark renewals follow similar points here regarding the renewal of registered trademark, of registered designs. Trademarks are renewed every 10 years, 5 for designs. And if the renewal date falls after the 1st of January, you can't avoid paying the UK renewal fee by paying early. You must pay the UK renewal fee from 1st of January onwards. And any renewal fee falling due after 1st of January will be subject to the normal UK renewal fee. Renewal deadlines will be calculated from the EU or international registration dates. And if a renewal fee falls due within 6 months, as I explained before, for designs, the UK IPO will send a notice giving you 6 months to pay, normally with a surcharge. However, during that 6-month period, the UK will waive the surcharge for late renewal. Of course, if the renewal fee is not paid, the mark will be deemed expired, and UK restoration process is possible because this is now a UK right. Similarly, for late renewals, again, this is the same for designs and same for trademarks. If the trademark renewal falls within 6 months in the period prior to Brexit and you haven't paid it, you're relying on late payment, the trademark registration will automatically get cloned in an expired state. And if the renewal fee is paid within the 6-month period, that will then be removed and put back to a live registered state for the international or EU registration. But beware the requirement for the UK IPO to be notified regarding any, bear with me, any UK, owners will be formed the UK, and you have to inform the UK IPO by the 30th of September that you have renewed an international application, not necessary for EU trademarks. Bear with me, I see we've lost controls. Let me just get them back. Oh. So with regard to cancellation opposition in trademarks, of course, there are contentious proceedings far more so than designs. EU trademark registrations or any international designations can be subject to cancellation actions, and the UK IPO have stated they will honour a cancellation action on a cloned UK trademark. If a pending or future opposition at the EU IPO is based on the prior right only in the UK, then of course when the UK leaves the EU, that prior right falls away. It's no longer a prior right in a national member state of the EU, and therefore your ground of opposition is null and void. And we've been seeing quite a lot of these quite proactive actions by the EU IPO in effectively informing us of the nullity of an opposition, warning us that this case will fail. So beware of finding a continuation of trying to continue an opposition based solely on a UK right. If a pending or future opposition against the UK trademark is based on prior EU registered trademark, this prior right will continue as a cloned UK trademark registration, hence the opposition will continue. Now, the other point to remember here that use of an EU registered trademark in the UK can't be used to support an EU trademark registration in defence of a non-use cancellation action. We're basically now separating the systems. Point on representation. Unfortunately, when the UK leaves the EU, UK practitioners will lose the right of representation before the EU IPO. There is an exception for this where there are ongoing proceedings, and that's quite detailed, relating to ongoing oppositions, cancellations, or an opposition that's filed against a case. The UK the UK representative can continue to operate. Some firms have offices in EU countries. Schwegman UK, we are a UK-based firm. We have partnered with a firm in Ireland to continue to provide EU IPO services. The new law will require all proprietors to have, the new law in the UK will require all UK proprietors to have a UK representative. And that's similar for designs. So what I wanted to do, getting towards the close here, is to talk about some practical issues for those of you concerned with dockets and registered, sort of thrown some things out there, and I've sort of pulled these together in this slide. Registered EU trademarks and designs need to have a cloned UK registration created with the same filing registration dates in your docket systems. They'll have the same renewal dates, but they'll have a new number format. And hopefully your docketing system provider will have already come up with some clever scripting system for doing this en masse to enable you to create the necessary docket entries with the right format and with the right data. Any renewal, so if those of you concerned with renewals, given you some indication of some of the issues you need to consider here. Any renewal falling due after 1st of January, you need to set up a UK renewal. So not just create the case, but ensure you have a renewal set up. And you can't jump ahead of that and avoid paying the UK renewal early. If it's due on the 1st of January, you need to pay it on the 1st of January, but you will be given 6 months grace for free without incurring additional fees. So there's no need to panic and everybody rush to pay renewal fees on the 1st of January. There's plenty of time. For those of you in the unfortunate position of having cases in the late renewal payment period overlapping Brexit, you can, still rest assured that you're able to pay the renewal fee late with the surcharge required by the EU IPO or WIPO, but beware the requirement to notify the UK IPO by the 30th of September 2021 at that email address that I gave in the presentation above. So pending EU trademarks. Now, pending EU trademarks, of course, include those being opposed. You'll need to create a new UK trademark application matter with a filing deadline of 30th of September and carrying over the EU application and priority date. So there's some dates for those of you. I'm sure most of you have, or at least those responsible for your docketing system have got that covered, but I just wanted to summarize those. So in summary, Brexit does present significant challenges and changes in the IP landscape, particularly for trademarks and designs. I've only been concerned with certain aspects of the legal position, but there's still a lot of clarity required on the commercial and political position. We don't have an exit agreement in place, and there is a very real threat of potential what we call no deal exit, where we leave without clarity on anything, and then it's trying to sort it all out over the few months into 2021. We'll see where that leads us. So Brexit will clearly have an impact, but on cross-border movement of goods and service, but the extent of this, until we have a clarity on the exit agreement, is really, we really are unclear. So hopefully that gives you some insight, overview in a package of where things impact primarily on registered trademarks and designs in the EU. And for those of you concerned with EU trademarks and EU designs, an outline of what is happening, what you need to do. And with that, I now open it up to questions. And I see, hopefully we have a few.
Yeah, thanks, John. We do have a few questions that came in during your talk. I'll just start at the top and we can work our way through them. So Benjamin asks, how long do you have to provide a UK service address, and will you lose rights if you don't provide one in time?
No, what will happen is if you have a non-UK representative, then that representative is no longer qualified to represent you before the UK IPO, and they will therefore seek to write to the to the applicant. And if that applicant is the UK, you won't lose your rights. And it's just that you will have communications going to a foreign address and generally possibly to the applicant rather than the representative. When we use the term address, UK address for service, it's a term that we use in the UK. We really mean a representative. Non-UK representatives can no longer represent. UK representatives can, but an applicant can still represent themselves. We don't exclude that happening by this cloning process. So there's no loss of rights. It's just beware that important communications will not go to a representative. If you had a European representative before, they will then start going to the applicant. So just beware of that.
Great, thanks, John. All right, so David asks, how will the UK IPO handle trademark applications in process with the EU IPO?
Okay, that's some of the slides I was going through there. I explained I could try and skip back to those to recap. This is where you don't get automatic copying, cloning across. I'm trying to find, here we go, pending trademarks. So to remind you, pending trademarks are not cloned across automatically. You have this deadline of 30th of September to refile, should we call it, the application in the UK IPO. So the simple point here is that pending trademarks, pending designs, it's the same for both, are not automatically cloned across. You have to take action for pending trademarks and designs, and you have to take action by 30th of September by the filing of a new UK application. The UK IPO will be amending their application forms to include the appropriate boxes for you to tick, and your representative will know how to do this to ensure that you capture the rights of your European application in order to do that. Okay.
Great, thanks, John. So our last question that at least we have typed in at the moment reads, is there a time restriction on the conversion of an EU trademark application? Example, could we request an EU or a UK conversion for an EU trademark application that was abandoned in 2018?
If it was abandoned in 2018, the only, it sounded, in that case, the answer would be no. Let me explain more clearly. There is an option where you get, let me see if I can put that slide up. When a UK application, when an EU application is, I'm trying to see if I can find that one as we talk. I was looking for so I can find a seniority. I'm not going to find this quickly. Conversion, here we are. Where an application, the conversion process, where an application before the European Intellectual Property Office is cancelled or surrendered, you have a 3-month term which allows you to convert this rejected, refused, abandoned, use all the terms to make it clear, whatever, when it's no longer allowed, you can have 3 months to convert it to national rights, only 3 months. After that, there is no restoration, well, potentially a restoration, but a limited term, and for good reason, very good reason. So if it's pending, if it's refused, rejected, cancelled, then you have this 3-month term. So you can't reach back to sort of rescue old European trademarks that are dead and buried and try to sort of resurrect them in the UK IPO. No. Of course, at any time you can refile trademark applications. The trademark system, unlike patents or indeed designs, does not rely on novelty for you to apply to register your trademark application. You don't worry about disclosing it and it not being new and inventive or a new design. The trademark system is based on the ability to register a right to protect you in commerce if you are using that. If you have been using it but you didn't register it, then indeed your use prior to registration may assist you in the mark becoming distinctive through use to overcome potential objections to non-distinctiveness. So the answer to that is no, you can't reach back for old, expired, dead applications. The conversion period is 3 months. So if you have any recently refused cases, you can convert.
Great. Well, thank you, Dr. Collins. Appreciate all your insights here on what's going to happen here come the first of the year. We don't have any further questions. So I guess we'll wrap it up, and we'd like to remind people that this webinar will be available, in short order on our website, and to please, follow us on LinkedIn for future webinars. Thanks, everybody.
Thank you.